The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome back to Mediator in the Middle, a podcast about mediation by mediators for lawyers and their clients. I'm your host, Abe Melamed, and today we're very excited to announce a special episode of the podcast. Today, you're going to get to peek behind the curtain of what actually happens during a mediation. We have two phenomenal guests. One is a plaintiff's lawyer, one is a defense lawyer, and they're going to mock out or moot an actual mediation of a sexual harassment case. They don't know this yet, but this case is actually taken from a real jury verdict. And we're going to get to see not just how the mediator operates, but how the individual parties operate. You're going to get to peek into what goes on in each of their rooms throughout the mediation process. So let me tell you a little bit about the facts. Let's go on this journey together, and we'll see where we end up at the end of the day. So this case is about a plaintiff. Her name is Sarah Jones, and she worked as a manager at a clothing store in a mall. Sarah was employed for about 6 months, and during that time, she alleges from the moment she was hired through the moment she was fired, the owner of the store, Jason Smith, subjected her and other employees to sexual harassment. Sarah alleges that Mr. Smith catcalled them, made sexually harassing jokes, made comments like, "Oh, your ass looks great in those jeans," or "That dress shows just the right amount of cleavage." Sarah alleges that after working at the store for about 5 months, defendant Smith then propositioned her for sex in exchange for a raise, specifically oral sex. She refused, and she alleges that he threatened to fire her. From that point on, Sarah alleges that defendant Smith made demeaning comments, sexist comments, called her a slut, a whore, told her to clean the floors because she's a woman, and sent her sexually explicit text messages. And after about a month, Sarah alleges that Jason fired her from her employment. Defendants, on the other side, vehemently deny the allegations, absolutely unequivocally deny ever making any sexually harassing comments or propositioning Sarah or anyone else for sex. And defendants say he barely even saw her throughout her entire employment at the store. And immediately when these allegations were raised in this lawsuit, they hired an outside law firm to conduct an investigation, and the investigation found no corroboration whatsoever, and there's a written report to that effect. Defendants also said that plaintiff's reason for bringing this lawsuit is she was a disgruntled employee who was just upset at the company for firing her for legitimate reasons. Defendants also contend, and this is an important legal element, but they say even if the facts were true, and we vehemently deny they were, but even if they were true, plaintiff does not have significant damages. She has no expert report, and she does not have independent treatment. So we just don't see any significant emotional distress damages. Her economic damages don't exist. She's not even claiming economic damages. So even if this is all true, what's the worst case scenario? A jury is not going to give a lot of money. So that's the scene we walk into. That's the stage that is set for Jeff Thurrell and Mona Tashroudian to begin this negotiation. There will be some back and forth about some of the facts and information, and then we're going to get into the negotiation. Thank you for joining us. We hope you enjoy the journey alongside us, and we hope that you'll give some feedback about what you think the outcome will be and see how close you get to the outcome. Thanks for listening and watching. Have a great day. Well, thank you for being here, Mona. I appreciate it. And, I've read your brief. You were very thorough. I appreciate that. It really laid out a lot of the facts. I see what your client alleges happened. It's terrible. If this happened, there's just no excuse, no way about that. I think that a lot of what we need to do today is exchange as much information as possible with the other side to try to progress things along to see if we can get to a resolution. Obviously, there's always risks with litigation. You can go to trial and win. You can go to trial and lose. It's a coin toss. We all know that. We've won cases we thought we'd lose and vice versa. So what about your client or about the facts you think is important for me to know?
So pretty much everything in terms of the harassment and the comments, which were very egregious, which were made to my client, are in the brief. I think the sticking point and the issue here up to now, and we're just about a month out from trial, and we've defeated our MSJ.
To explain mediation jargon, here's my 6-year-old daughter, Mia.
An MSJ stands for a motion for summary judgment. That's where the party asks the court to dismiss the lawsuit before it even gets to a jury.
Is that they don't understand the gravity of the situation, and I think they being the client, not the attorneys. So as I'm hoping a mediation, someone with your expertise can come in and actually talk to the defendant. I understand he's there, maybe there today or available. So really to get it across to him what it would look like. I don't think he's ever been sued for this before, for sexual harassment, which is interesting to me. And it's the reason my client is here, because this continues to happen. It's happened to other employees, as I provided in my witness statements that were attached to our brief. So it's really just getting the message across, and they need to take this seriously. And I'm hoping they get that message today.
I appreciate that. So one of the critical things I know you talked about in the brief is you have these 3 witness statements from other women that were sexually harassed by the same defendant, by Mr. Smith. So, are you comfortable with me sharing that information with the other side? Ideally, if I can give the actual statements to them to look at, it would be helpful, but I know you haven't exchanged that. I know those names are on your witness lists, but you haven't shown the defendants the actual witness statements from them. How do you feel about that exchange of information today?
You can share the content of the statements at this point. If something changes during the mediation, I'll let you know about showing them the actual brief. But at this moment, it would just be the content, but keeping the names anonymous.
Okay.
While you share the content. So you can call them, witness 1, witness 2.
Sure. And
But
just
they haven't
identify
seen
what.
this.
Okay, that's helpful. I think they need to know what other people will say, because the corroborating witnesses often make all the difference in these trials. As you know, you've been very successful in getting verdicts before in cases like this, which helps also with the other side. They take this seriously, considering you're the representative. Let me ask you a couple other quick things. So there's allegations that there were explicit text messages exchanged, but I didn't see any copies of that. From what I understand, nothing has ever been exchanged. I know that's going to be an issue they're going to ask about. Did your client ever text a friend or family member? Is there anything else that I'm not aware of that you have? Because look, the reality of this is, give me every piece of ammo you have. Let me take it to the other side and work on them to try to get the most possible today.
Yeah, so a lot of them were made verbally while at work. There were a few text messages, and unfortunately, this happened now through litigation. It's happened a few years ago, and she wasn't planning on bringing this lawsuit. Those text messages have been destroyed, unfortunately. We've asked for them from the defendant. It's my understanding he has the same phone, so I don't know if they're hiding the documents, if they haven't produced all they have. Unfortunately, on our end, I don't have the actual text messages. She has spoken to witnesses such as her boyfriend. He'll come in and say that he saw these text messages. We'll have to deal with potential hearsay issues.
Right. There may be hearsay issues.
Yeah.
Unless there's excited utterance, she's describing how upset it made her, or present sense, or
her reaction to receiving these texts. Like, it's even if, aside from the content of what was said, it was the way she reacted to receiving a text from her boss. It's not like, okay, something casual you just get from your boss. They're very explicit, very demeaning sexually in nature, and so we'll have those type of witnesses.
Fair enough. That's helpful to know. And I think that, look, if a jury believes what happened to her, what she's described actually happened, I could see this being a very significant award. I think we all recognize that, and it's just really a question about the uncertainty of what can happen through this process. So let me go to the other side. Let me talk to them a little bit. If there's anything else I've missed that you think is important to note, let me know. But otherwise, let me start to kind of get the exchange of information from them and see if we can make some progress and get your client the best alternative to what the option existing right now is. And that's a grueling trial that's not going to be fun for her. So anything I missed that you think is important to note?
No, I just want to reiterate the gravity of the text messages. Also, using words such as slut, whore, telling her to clean the floors, just very demeaning to women. And we'll try our best to get a jury. I mean, men too. Like, men don't want to hear this stuff. So it'll be equal men, women, and I don't think any jury in California, in Los Angeles, will want to hear these facts.
Yeah, there's certainly a shock value to hearing those sort of comments. So that's understandable. I appreciate that.
Sure.
All right, well, hang tight. Let me go to the other side and let me talk to them for a little bit. Just stay busy, stay hydrated, stay fed. So blood sugar never drops. We never want to negotiate when we're hungry. And I'll be
Sounds
back
good.
in a little bit. All right.
Okay.
Thank you. All right, we are back. Thanks for patiently waiting. I know it's a process on your end, and there's a handful of things that I've learned from the plaintiff side beyond what they put in their brief that I think will be helpful to discuss. But why don't we start with your side? Just kind of what your facts are, what your experience is. And I'll say your brief to me was very thorough. I really appreciate that. I hope your client recognizes that they've done a great job in selecting very able counsel. I have some questions about the investigation file and the investigation that was conducted, and some about the handbook. But let me just start with that. What's your perspective on this case, Jeff?
Well, it's one of these cases with obviously some pretty serious allegations against the co-owner of the company. But when I talked to my client, Jason, he's pretty adamant that he hasn't engaged in this behavior. And he said, she said might seem a little contrite, but what we're not finding are things that would substantiate any of the alleged conduct. We are finding, when you do a credibility assessment of these things, you look at motives, and obviously, I guess Jason would have, some sexual desire. Motive would be the allegation in the other room, but is there a motive for somebody to make this up? Which is always something that I ask myself, and I think a jury down the road would ask is there something? And, the circumstances surrounding her termination were legitimate. And when you compare apples to apples as to why Miss Jones was terminated, it really shows that other people similarly situated felt the same wrath in terms of not having a position anymore. And she was pretty angry about that. So when you look through all this and you sort of peel things back, we're not finding substantiation of the conduct. I think Jason comes across as credible.
Sure.
And it's not all that complicated. I mean, you ask yourself, okay, were there policies in place that this person could have reached out? Now, I realize Jason's the owner of the company, but there is a handbook. There is an 800 ethics number that anonymous or not anonymous would have certainly triggered the other owners to look into this. I will say this, the allegations from the get-go are really significantly out of the norm with what you see in workplaces. Obviously, the quid pro quo allegation that occurred 3 months into this relationship, that's sort of a separate bucket. But the allegation that he's making these crass comments, I'm assuming out in the open, that really are over the top of somebody in his position, is very alarming. That she didn't leave immediately. You didn't get comments from witnesses that said, hey, she immediately told me this happened. The owner made this offhanded, off-color remark. So I'm not getting, and so when you see some of these cases that you can kind of verify and you say, geez, where there's smoke, there's fire. Usually you get some witnesses that are going to say, yeah, she told me about this. We didn't even get that.
Yeah, well, I think those are great points. And one of the critical values of this mediation process is the exchange of information, because you are pretty far along in this litigation, but there are apparently 3 witnesses that will corroborate what she experienced, 3 other women that worked for the employer, 2 of whom are former employees and worked during the time that she was employed, that the plaintiff herself was employed, and another one who worked for the defendant after she had been terminated. So all 3 of them are not with the company anymore. From what I understand, they weren't terminated. They were people who left of their own volition, and it was because they had witnessed similar comments. So I've had a chance to review those, and I know that we've had good experience. I know there's a level of trust that you can understand. At least I'm conveying what I've seen. But if it gets to this stage in the mediation where we're making progress and you need to see those actual statements for it to make a difference, we can maybe talk about that. But these are people that are on the witness lists that have been disclosed over. They're people who the plaintiff will be able to call at trial. And they pretty much corroborate these types of comments were commonplace. These types of text messages were sent to them as well. Maybe not as egregious as the comments that the plaintiff's alleging here, but some pretty sexual comments. The 2 witnesses that were there while the plaintiff was still employed talked about having witnessed him making comments like this to her in person. So I think that has to be something significant that changes the calculus on your end, knowing that there will be that corroboration going into trial. And even with that, obviously, we all know there's uncertainty, and I've conveyed that to the plaintiff. She understands, plaintiff's counsel understands that even with that, sometimes you go to trial and you lose, and sometimes you go to trial with a lot less and you win. But I think that has to play somewhat of a role on your end. So any questions or thoughts about that?
Well, yeah, I mean, I know on the witness list, opposing counsel put every current and former employee
Yeah.
on there. I'm a little blind on this because I haven't
Sure.
gone out and taken the 82 depositions
Mhm.
that we're going to need to do before trial. So in terms of the credibility, I would give that, unless I know the identity, so I can go back to my clients
Yeah.
and find out whether there is some sort of potential motives behind making comments. I don't know if these people are friends outside of work.
Mhm.
So there's a lot of in a
Questions you'd
vacuum.
want to ask,
Yeah,
sure.
exactly. And so we've got a demand that's a 7-figure demand, which is really high for somebody who is a $16 an hour employee
Yeah.
without medical treatment that's substantiated, where it's sort of a number in the sky kind of
Sure.
number, as
Yeah.
you know, and I mean that's the way it goes. We're here today, but I think as this moves along, at some point, if we're not just getting somebody who's pounding their chest in the other room,
Yeah.
we're going to need to know more facts about those
About those
witnesses,
statements.
because ultimately I'll find that out before
Sure.
trial and assess it, and that is what it is. If it were me on the other side, I would have shared those coming into the mediation.
Yeah.
So I can do my due diligence. I might have a spin. She might not buy into whatever that might be.
Yeah.
But catching me blind today is
It's
never
not
going
as
to move the
productive.
needle.
Yeah, which I agree, and I communicate that always. I think the concern here is the identity of the three. They're not employed, so they don't have the fear of retaliation being fired, but they do have concerns generally about being identified. And then I think the strategy from the plaintiff's counsel is go try to take those 83 depositions and figure out who these three people are. Otherwise, you might find out at trial we call these three people and you're getting blindsided. So I'm very, very much a big believer in the exchange of information, but I can kind of recognize a little bit of that concern from them and the strategy involved. But I do think that as we make progress, and I think we should start, getting into the numbers, although I have a couple other questions. As we make progress, if it seems like we're going to start getting towards a delta that we might get it resolved at, that might be something I can push plaintiff's counsel then to say, look, they're not acting in bad faith. They're not here for free discovery. They really just need to be able to see this to assess it. And maybe even we get to a mediator's proposal at the end of the day and you get to take that back to the client, let them investigate that a little bit for a week before making a decision, something like that.
A mediator's proposal is when the mediator suggests a number that's somewhere in between where the two parties are, and if one side accepts but the other side rejects, then the side that rejected never knows that the other side accepted. So then both sides are in the same place they were in the negotiation before the mediator's proposal.
Does that sound fair?
That sounds fair.
Okay. So the other question is just on your end, I know that you have the handbook and you have a complaint procedure that's laid out. And from what I understand, that hasn't been a big issue on the other side. I'm assuming you're okay with me talking about that and pointing out the fact that she never made a formal written complaint.
Oh, absolutely. Absolutely. Yeah. I mean, I know that, what's even more insulary with this company is, I mean, these are sophisticated folks. I mean, this is a robust human resources department that has multiple facilities. Like I had mentioned before, this is an 800 number that can go anonymously. And while Jason is one of the main owners, there's a lot of other ownership folks
Could have
behind
gone
him.
to. Yeah.
And that's just going to raise a red flag. And so this isn't really a mom and pop that might not be sophisticated as to what the obligations are in terms of an investigation, or understand the potential pitfalls with turning a blind eye to something like this, if this is really occurring. So, I mean, I think hammering that home, I know that All new employees are onboarded with a handbook. I know that Jason was not the person who did the onboarding. There's a manager there that specifically, as per their training, goes through many different things, but certainly spends 10 or 15 minutes on behavior and what to do if you don't feel comfortable in the workplace. And that's part of a word track that they're trained on. So obviously it's something I would raise. I know what the response is going to be. But
Obviously she'll say, she made a verbal complaint and a complaint is sufficient, but I think it definitely makes a difference that she received the handbook, knew there was a written complaint procedure, chose not to do that. But I also don't know if it's a critical element, just because if a jury believes it happened, he's clearly her supervisor, you're going to have strict liability anyway.
Strict liability is where the employer is liable, even if they had no idea that this was going on. The law makes them liable no matter what.
But I think the reason I would like to focus on it with the plaintiff is it tends to militate against the credibility of the plaintiff.
Absolutely. No, I totally agree. And, one of the questions I asked plaintiff in the deposition was, I get that you don't quit your job because you need it to pay your bills and keep the lights on and keep food on the table. But she couldn't articulate and identify any other job prospects she was looking for during this time.
Right, which you would imagine she should be looking everywhere she could to find something to replace it.
Absolutely. I mean, it's one thing to keep your job, and I get that, and that makes sense. You got to have something, and you don't want to get evicted. But on the flip side, in what is clearly a buyer's market, job market, no evidence that she applied for any jobs.
Don't mind me looking down. I'm just going to take notes. I think that's a great point.
And I think that kind of goes to if it's that uncomfortable, severe or oppressive, severe or offensive environment, I sort of think that most people would be out scouting pretty aggressively to find something else and to make that happen. And there's no evidence that happened. So I think that goes against her credibility as well. I mean, look, Abe, I'm pretty transparent. I don't have a crystal ball. I don't know. Yeah. All I know is how I think my witnesses are going to come across credibility wise. And if a jury believes this was a jovial working environment where people might make comments back and forth, et cetera, and maybe Jason partook in some of them, but nothing super explicit comes out. I don't know what these witnesses are going to say or what their motives are. That's a far cry from exchanging sexual favors for a raise or threatening termination. Those are there's a wall there that I think is pretty high to cross when you go from a sort of a locker room environment, which I'm not condoning, to a quid pro quo situation.
Yeah, I think that's fair. Look, in terms of numbers, we'll get into it in a little bit, but I think you're right. They're starting at $3 million as an opening demand. So, that's a significant place to start. I think they're viewing it as a really serious case and that they could get a 7-figure verdict from a jury. Mona has some serious verdicts. She had a $6.3 million verdict in a sexual harassment case not long ago. So I think that has to be something of a factor. They're not one of those firms. We all know the firms that don't litigate. She's definitely not one of those. And I suspect, just based on that opening, that they're targeting a 7-figure number today. I like to play chess, not checkers. That's the analogy I always give. Don't start at 3 and come back with this and a little. Let's be strategic in our negotiation. And so I think that's really the question I would start thinking about and prepping for with your client is, could they ever see themselves paying a 7-figure number? Obviously, it's never going to be a 2 or a 3 million number, but once you cross that threshold from 900 to 950 to $1 million, $1.1 million, $1.2 million, that's where I think it starts getting really enticing in a case like this for the plaintiff to consider it. So first and foremost, what would you like me to go back to them with in response to that 3 million demand? I think you got to put something substantial to show that you're going to make a little bit of movement, but still to demonstrate we're worlds apart. What are your thoughts there?
Yeah, I mean, I've been doing this 23 years, and I can count on 0 hands how many 7-figure single plaintiff settlements I've had on any type of case. Not that they wouldn't be warranted in some situations, not that they don't occur in a lot of situations in today's environment. I just personally haven't been part of them.
Yeah. Fair enough.
And so when you look at that kind of number, maybe I'm skewed, but my clients stuck with me in terms of how I value the case. There is no physical assault in this case,
Yeah.
which moves the needle pretty dramatically in my mind. If you go into a jury and you get whacked on something like this without major substantiation and a showing that the environment was just horrific,
Yeah.
I don't think you get anywhere near the 3 million pop.
Sure.
Maybe you hit 7 figures. Who knows? Depends on the venue and depends on how the witnesses come across. And
Yeah. There's Stanley Mosque, and then there's Riverside. We all know.
Yeah, it depends on how Jason comes across. So in terms of valuing it, I'm fine to ignore the 3 million, but you have to message it that way. Like I'm pretending like that's not even there. And my goal is to leave sooner rather than later, because if we're this far apart, I'm not going to sit here all day and put my client through this. So I'm going to ignore that first offer and probably come in at something, I can come up with something more than the 10,000. I can offer 50 to say we're here seriously and we've already spent, over $100,000 in litigation fees.
Yeah.
And I will tell you, it's very rare that I would put that kind of money on the table, but I'll do it at your guidance. But it has to be with caveat of a message to the other side that I am ignoring 3 million.
Yeah, that number's not relevant.
Yeah.
Well, I appreciate that, and I appreciate your willingness to start with a strong position, because I do think the sooner we can get, and I'll start poking and prodding them where their numbers are, and maybe you end up with a number that's under the 7-figure mark, but I think that's where they're coming in today. So let me talk to them a little bit more. One more quick thing I just want to go over. I know that you had an investigation done by an outside law firm and that you're claiming privilege over that investigation. To the extent that investigation becomes somehow material to your defenses, whether it's avoidable consequences, whether it's punitive claims, if there is an investigation immediately, there can't be punitives. If you're going to assert that in some way in this litigation, I think they'll have a pretty strong argument to be able to get a copy of it. You can't use it as a sword and a shield at the same time. But presuming that it says what you've put in your brief, which is that it's pretty thorough and there's no corroboration, I think that would only help on the other side to be able to say, look, they're going to be able to put up this testimony that there was a thorough investigation done with no corroboration. So are you comfortable with, let's just say to start with, similar to how they've conveyed the information in the witness statements, that I just convey what the information in that report is? We keep it.
Yeah, I think that's fine. My take was, given where we're at currently in the litigation, that it was a conservative play to not waive the privilege. But I'll be honest with you, I taken on the 4 corners, we're going to end up waiving that.
Yeah.
And we're going to drop the report. And it's going to be super helpful. And what I put in my brief echoes really what the report says.
Sure. Okay, so let me go ahead and convey some of that and some of these other points that's really helpful. I always say, give me as much ammo as you can to go the other side and push them. And let me go start talking to them. But I'm going to convey the 50,000 as your opening, and I'm not going to say it as in response to. It's going to be almost like you're ignoring that 3 million.
Great.
So, all right, thank you so much. Hang tight. I'll be back in a little bit.
All right.
Okay, I'm back. Can you hear me okay?
I can.
All right, good. So here's where we are. We made some progress. I've conveyed a lot of that information. It was really helpful, I think, for him to understand the perspective you have, the perspective your client has, and talk through your experience being a very successful litigator. I think they're taking it seriously because of that. I conveyed the information in the 3 witness statements. I think it certainly made a difference, although I'm sure, the poker face didn't tell me that it did, but I know it must have. I think probably as we get closer to resolution, if we can get there, which I hope we can, I feel pretty strongly we'll be able to, it may be important to exchange that. One of the important things on the other side that I think has to affect your valuation a little bit is they do have an independent investigation that was conducted immediately after this action was filed, which they're going to rely on to some degree to allege there's no basis for punitive damages. They might rely on it for an avoidable consequences type of argument. They've asserted privilege over that. I know that was in the privilege log that they sent to you, and they haven't exchanged it, but I did talk to Jeff about whether or not he'd be willing to at least just exchange that in the mediation confines. And so I think maybe a mutual exchange of both of those pieces of information, let him show you that investigation report, let you show him the statements, might be kind of a mutual way of, mutually assured destruction type of thing if anyone did anything with it. But I think that's really going to be helpful, mostly because there's no corroboration in the report. The investigators report basically said, talk to current and former employees. No one's corroborating these types of comments, things like that. And so there will be hearsay issues. The report itself may not get in. It might come in other circumstances, but I think it's helpful just to see that and how it might affect credibility. So that's the first thing. The other is, he made a point that your client didn't really look for other jobs during this period of time. She's there for 6 months. She's alleging this is a horrible, terrible environment, but she doesn't have any job applications during that period of time. And Jeff's astutely pointing out, you would think someone going through this, maybe they can explain why they didn't quit their job. And your client did a great job explaining that in her deposition. Look, I couldn't quit my job. I couldn't afford to. But there is a question, why aren't you looking for other jobs at the same time? So I think those are kind of some of the key points that I think need to affect the valuation a little bit. That said, they did come back with $50,000, which is a substantial start, as you know, from a defendant, even in these types of cases, even with these series of allegations. Oftentimes they're at $5,000 or $10,000. And I always say, don't waste time on either side. Let's try to keep the ball moving. Jeff was very clear in saying you need to convey that this is not in response to $3 million. They're not trying to signal to settle somewhere in the middle. I think he's basically saying we're going to ignore that, and this is how much we're putting out as our first move. So I think that your first response to that, whether it's to drop more significantly or to jump straight into brackets where we start talking about midpoints.
Bracketing is when one of the parties conveys a top number and a bottom number. So they're saying, I will come down from where I was from this number to a new number if you come up from where you are to another number. And what they're really doing is conveying the midpoint, which is the average of those numbers. So for example, if I'm at 500,000 and I want to drop, I might say I will come down to 300,000 if you come up to 100,000. And what I'm really saying is, if you came to the middle of those two numbers, which is 200,000, then I'll take it. This allows the parties to get to their real numbers a lot more quickly.
I'm fine either way, but my style as a mediator, which is different than some maybe, is to really try to get straight into the real numbers. So tell me first what you view as potentially a target that you would recommend your client taking today. Obviously, the 3 million is an opening start, but if I ever got them near 750, 800, 850, is that something you say to your client, at least think about it?
Yes. I mean, that's close. Without at this point disclosing our bottom line, that's, something that she would be comfortable with. I mean, I would have to talk to her.
Yeah.
But she really, as her counselor and her attorney, really does trust my advice. So I would be comfortable for the type of a case accepting something around that figure. But two things, just to base off what you would, your discussion with counsel. In terms of the report, I think we can just tear it apart. I think, it's a hired gun. It's obviously there's going to be no corroboration. I don't think the jury will give it that much weight. It's not really a neutral evaluation, in my opinion, and that'll be the argument to the jury. And then in terms of the job issues, I think that's moot. We're not seeking any past or future economic damages. It's just clearly emotional distress. So that won't even come up.
Right.
The damages.
They won't get to explore that, you think?
Yeah. So
because his way of exploring it would be bringing it through economic damages, but since there are none, he may not even get to ask that question at trial.
Yeah. So
Fair point.
I don't think that's any, help. It's not helpful to them.
Sure.
And between us, the reason she couldn't find a job, she didn't leave because she had to support herself, and it's hard these days. She couldn't just quit.
That's true. It's a tough economy, yeah.
Yeah. And then she was really just traumatized by the whole incident. She had PTSD, just really couldn't even apply to jobs for a while. So anyways, but still,
Sure.
again,
No, I think that's really helpful to know, and I'm gonna get authority to just share the actual report so you can see it. But I think those are great points that I will make. If we get closer to resolution, we can talk about exchanging those witness statements too.
sure.
So,
And our opening demand of 3 million, it was a high number. It wasn't a pie in the sky.
yeah.
I mean, I received verdicts of, $6-7 million, but
Sure.
I think a jury should do that. I mean, this guy and
Mhm.
in his deposition, he just comes across as like unbelievable, incredible. So
Yeah.
he doesn't present well either. And I don't think a jury will like him, to be honest. So I could see punitive being awarded, especially after our 3 witnesses do testify. So I don't think, I think a jury verdict could go upwards of that.
Yeah, I don't disagree. I think if you get to jury awards a verdict, it could be in the millions, but there's always the uncertainty. There's the cost, there's the trauma your client goes through in getting through that process, which we want to try to avoid. But most critically, losing is zero. So there's got to be some range in, coming into a settlement. I always say no one ever lost a settlement. That's what we're here for. It's just to try to bridge that gap. So what would you like to go back to them with in response to the 50,000?
In the interest of trying to tone this down a little bit, time wise, just to get this a little bit bundled up and to see where we can go. I don't like making small moves.
Sure.
And we're starting trial prep like tomorrow. If this case
Yeah.
doesn't go, we're just that close to trial. So this is like the last dish effort at getting this case settled.
Mhm.
But with that and kind of your figure in mind, I'll go back at 2.5, which is drastic.
Okay.
It's $500,000 drop.
I appreciate that. That's some significant movement, and I think it will convey that much to the other side. I hope they'll continue to respond in kind, and we can push them up from the 50 to 100 or whatever it is to start inching our way up there. But I would start thinking about that end goal, and it may come from a mediator's proposal. The reality is they're probably looking at this and saying we don't want to pay more than $300,000, $400,000, $500,000. I think if we can get them above that, it's going to be a good outcome, at least in respect to that. So let me work on them. I don't know. Maybe they get 10 million, maybe they don't, but I'll keep that in mind and make that a target. Let's see how they respond. All right.
Yeah. And again, we're not scared to try this case. So whatever it takes.
Fair enough. All right. Hang tight. I'll be back.
Okay, sure.
I'm back, Jeff. Do you hear me okay? All right. Staying busy over there, I assume.
Yes, absolutely.
All right. Well, I think that was very helpful, very productive. Some of the information I shared, I think definitely landed, and they're starting to think about numbers coming down. They did make a substantial move. They came down from 3 million to 2.5 million, which is a $500,000 drop. I know that starting at 3 million, where you view it in the stratosphere, it's like, well, you could start at 100 million and drop, but I think it's a pretty significant move from them, and it reflects that they are interested in trying to get this resolved. I do still think they're probably targeting somewhere in that 1.5 million range. And so I think the hard work today is going to be getting them down below that. And I won't know until we get there. At some point, you're going to tell me, Abe, enough, there's no more money, stop asking. And that's something I'll have to bring back to them and push them on. But I'd like to keep the ball rolling as much as possible. And they were comfortable with sharing those witness statements if we can get to toward a resolution. That's something you'd be able to take back and look at, and whether necessary, if we have a proposal out or something, even take some time to look at. So
yeah, I'd have to, if they're really in that ballpark, and it's going to have to probably end with some type of proposal, which where they're at and where they're telegraphing, even if it was substantiated, I still think the number's off.
It's gonna be hard.
I would have a real hard time ever recommending 7 figures.
Sure.
To the client, even if what you're telling me about their statements is accurate based on our investigation. But one of the things I like to get out of a mediation is what really is the number. And so I don't want to lose sight of that too early in a huff and shut things down. So in terms of moving it along, I think you need to go back and say, I've got maybe one more of these moves in me. So, I would put things at 75, which is half of what was a very, very generous opening offer. But I'm not, I understand you've got to get them moving, and that's your job. And I'm not taking it out on you, Abe. And we've worked before, and
I think that's fair. That's fair. Look, I'll tell you, Obviously it's not going to get done for this type of a low six-figure number. And I think if we can get them under the seven-figure range, it's going to have to be at the top side of that. I would rather, if you were comfortable with it, going back with 100, if you have that, to just keep the ball rolling. But I'd like to maybe shift them into brackets to start conveying a real midpoint of where they could see it resolving. The sooner we get into that range, the sooner you get a sense of it, the better. What are your thoughts?
Well, I mean, I think I'm going to get a bracket either way from them, whether it's 75 or 100. And, you know, normally I tracked you pretty aggressively on the first one not to come back
Sure.
with 10,000, because 10,000 would have maybe sent them out of the room. And here we're here. This is getting expensive for everybody. But I'm not going to track into six figures when they're still at a number,
That's a significant. Fair enough.
Well, I feel like the result is it's not going to be received any differently, and it sends a message.
It's going to be the same.
My number higher, and until there's a lot of verification of a lot of things, I would have a hard time, you know, talking in these terms.
Sure.
So let's go back at 75. I think getting a bracket is good.
I'm going to work on that, but let me ask you this question, because I think, you know, I know you got a hard cutoff at 3. So, you know, in your mind, if I got them into a range, if we got to the end of the day at a proposal somewhere around $1 million, and you get those statements and I'll get them for you and you corroborate everything, is that a proposal you take to your client and at least let them consider you think they might actually think about?
Yeah, I'd let them consider it. It really is. I mean, it really is what's in those statements, and and then it's my client's decision. I can't give you. I mean, a lot of times in a mediation and mediations we've had before, you know, we come up with a number. It's usually a hell of a lot less than something close to $1 million, and you say, "Would you recommend it?" And I will give you my affirmations, so you can have some degree of clarity with this proposal. In this case, I'm not going to be able to do it because of the vacuum of unknowns. But will I present it to them? Yes. Will I flesh it out? Yes. Will I say, here's your pros and cons? Of course, because that's what my job is.
Yeah, fair enough.
You know, and as I said before, we start this case, and I'm 23 years into this little marathon that we have, and never once, not a one, 7-figure settlement. And
it's the first time for everything, but fair enough.
Exactly. So if my reputation's getting out there, I have to hold firm to that.
Fair enough.
Anyway, so we'll go back into 75, and then you know, maybe she comes up with the bracket.
Yeah, let me take that.
I can do a counter. Okay,
I think that's fair.
Great.
All right, I'm back. I want to try to speed things along because Jeff's going to have a hard cutoff at 3, and we got a short window here. But I would ignore the number. They said we appreciate the movement, but you're still up in the stratosphere. They went up from 50 to 75, so they're putting some money on the table. But I started to have a real conversation just about where they might be able to end. And the question I just asked Jeff was, look, if I could get to a proposal today at $1 million, would your client consider it? Can you take it to them? Would they think about it? And, you know, he kind of hemmed and hawed and said, I'm not really, you know, I've never seen this happen in 23 years of litigating, that we pay that kind of thing in a settlement, but I'll take it to them. So I think the lower under $1 million we can get to that your client might consider, the better, because the more likelihood they'd accept it. But I don't know if you've thought about a real cutoff where you could see that heading. I think we're better off doing a bracket that communicates slightly above that right now, so we can try to bridge that gap. What are your thoughts?
I'm okay with the bracket at this point. I know time is, you know, running short, and I do want to try to get as close as possible. I hate to walk away when we could be close. I don't want to sell my client short, so I do think a bracket is okay at this point to see how close we can get, at least just so we know.
So what if we convey a bracket with a midpoint of, let's say, a 1.25? So that is a 2.5 total number. I think
do like 1.75 and 750.
Yeah, I like that. 1.75 and 750. That will give us a little breathing room from a 1.25 midpoint to try to negotiate it down a little towards $1 million and see if we can get a proposal there. Does that sound good?
Yeah, we're on board with that.
Okay, hang tight. I appreciate it.
Sure.
Jeff, are you there?
Those videos were so startling. You know, whether they're true or not, still going to take me time to get a back.
Really corroborate, and no, I think that's fair.
Coming to left field would have been a heck of a lot easier today.
Having an advance
a week ago.
Fair,
So
that's fair. And if you need the time, I think we may end up having to get to that point because I'm working hard on the other side. They're still a little in the stratosphere, but maybe that's where we end today is with the mediator's proposal that gives you a week to take them back to your client, really look at them. Here's where they are. They came back with a bracket of 1.75 to 750. So 1.75 million to 750, which is a midpoint of 1.25. That's really, I think, the key message. They're here to make a deal. They're willing to make those types of moves. I think I can continue to push them down from there towards that 7-figure number, and maybe we're getting even a little below that. But I think that's some good movement. What are your thoughts in response to that?
yeah, I mean, it's still out of the range I think my client would ever go, even with my recommendation on the midpoint number. I mean, obviously it got them out of ridiculousness of where they were at 2.5, and
Yeah,
so I kind of wish they had started there,
sure,
or
fair
started at
enough.
1.5, and here we are. I've got 75 on the table. I guess I haven't tipped much in terms of my hand. I mean, my thought probably would be to go back, and I don't think they'll respond to this, but if they want to entertain a proposal, it probably sends the right message to go back at a bracket where I put 225 as a midpoint on the table, which is going to signal a lot less than their dream day that they currently have on the table. That's sort of my take. So we'd have to pick the numbers
A
there.
short time, yeah.
We got a short time list. I would get that there, with the hopes that maybe something less than what you think it would take. Maybe they actually bite at it on a proposal. I don't know.
Fair enough. Okay, sounds good. Let me go take it to them. Hang tight. All right, well, they came back with a bracket that was conveying a midpoint of 225. So it's some pretty serious progress from that 50 and 75 they had before, but we've got this really kind of short timeline right now. I want to see if I can try to get towards a proposal. If you think about the midpoints of those two, right? If it's a 225 midpoint and you were at a 1.25, you're basically at a 1.5 total, which means a proposal at 750 is something they'd probably consider. I don't know that they take it, but they'd consider it. What's your sense? I mean, what's a proposal you think your client would actually consider? What's the lowest range?
So I just talked to her while you were in the other room because I wanted to help speed this along and understand what her bottom line is, and it's closer to the 900 to a million range.
Okay.
So 750, although it's closer to the 900,000, it's still below what
Where you want to be.
Yeah, and she's really experiencing a lot of emotional distress. Like
Sure.
It was bad. Yeah, I mean, especially
bad.
the incidents where the boss asked her for oral sex in exchange for a raise.
Yeah.
I mean, she can't even look at men anymore. It's ruined a lot. So
I think that's fair. So, I mean, do you want to go back with just bringing your bracket down a tiny bit from 1.25 to, let's say, 1.17 or something like that?
you mean the midpoint to 1.17?
Yeah.
Yeah, I mean, I'll even do 1.1 just to
Okay.
kind of keep
Let
the
me take
numbers.
1.1. Jeff's going to have to jump in a second, so let me go back to him quickly. I'll be right back,
Sure.
okay?
Sure.
All right, Jeff, I know you're going to have to jump in a second, but they came back with a midpoint of 1.1, but they were very clear the messaging is it's not to convey that they're in between that and your 225. My sense is I can make a proposal at 900 they'd consider. I think if I go higher, obviously it makes it more likely. Anything less than that, I think they're going to just outright reject. So I'm inclined to say, let me make that proposal. Why don't you take the time with your clients to look at the statements and see what they have to say about it? What are your thoughts?
Yeah, given that we're out of time today, I think we can go ahead and do that with
Fair enough.
the knowledge I've got a lot of follow-up.
You got a lot of work to
on
do
my
on your end.
and we certainly haven't signaled that we think it's
You didn't
there.
even consider it, yeah.
Okay, well, great.
Okay.
All
Fair
right.
enough. I appreciate it. Thank you so much for taking the time. I'm going to shoot you an email to follow up on this.
Okay.
All right.
That
I'll
sounds
talk
good.
to you. Thanks so much. I am back.
Hi.
So yeah, look, I think, they didn't have a specific response, but I had some conversations. I think I can make a proposal at 900 on the dot, and I think that that's about as high as they're ever going to pay. I think that it's unclear if they'll consider, or if they're really actually consider it, but in light of the statements, which they've now had a chance to review, I think they might actually think about accepting it. Are you comfortable with me making that proposal on your end, and your client will think about it? We'll see where she wants to go.
900.
Yeah.
Yeah, you can make it. That was a lower end of what my client wanted to accept, but
Mhm.
it's within the range. How much time would we have to consider your proposal?
I think they would need a full week because they have to review these statements and really feel like they have a sense of it. But I would give till next week and get a response from both sides.
Okay, yeah, and she and I can speak between then. I just don't want to give too much time because trial is coming up, so I don't
Yeah,
want
fair enough. Fair enough.
So I'd probably give 3 business days if we can.
Okay. 3 business days. Well, let me talk to them. Look, I'm inclined to give them what they need to review it, because I think once they look at those statements and talk to the decision makers, it will make all the difference. My guess is they're here with 5, 6, 700 maximum. To get them all the way up there, it's going to take some time. But why don't we start with that? And if they're going to need a little more time, I'm going to just send an email out on my own saying, look, everyone needs this extra time, so that they don't feel like you're even contemplating it, type of thing. Does that make sense?
Got it. Yep, sounds good.
All right. Well, I appreciate it. I know that's a lot of work, and I appreciate your client taking the time. That was a tough process. So thank you so much. And
Thank
I'll
you,
send that
Dave.
email with the proposal soon. Okay.
Okay, thank you for all your help.
Of course. Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. To book a mediation with Abe Melamed, the Creative Mediator, please email abe@melamedmediation.com. That's abe@melamedmediation.com, or give me a call at 510-842-7277.